Chevelle, I am Jennifer, the court reporter today. Can you please tell me what city and state you are currently in?
San Francisco, California.
Thank you, sir. Mr. Kahn, are you ready to go on the record?
Sure, let's go ahead.
I will ask counsel to please state on the record that you have no objection to me administering a binding oath to this witness remotely.
Matt Kahn for the plaintiffs, no objection.
Marisa Diddle for the defense, no objection.
Thank you.
All right, can we swear in the witness?
I lost him there for a minute. Doctor, if you could please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give in this cause to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right, good afternoon, Dr. Chevelle. My name is Matt Kahn. I represent the plaintiffs. I'm just going to get straight into it today. Do you admit that Kendall Thomas has a severe traumatic brain injury?
I would not phrase things that way.
That's the question. Do you admit that Kendall Thomas has a severe traumatic brain injury?
As I said, I would not phrase things that way. I have an understanding that she suffered a traumatic brain injury, that it has been referred to as severe, and that she now has severe or significant disabilities.
So you admit that Kendall Thomas has a severe traumatic brain injury?
No, for the third time, I would not phrase things that way. I would phrase things as I have.
Does Kendall Thomas have a severe traumatic brain injury?
That is my understanding, yes.
Do you admit that after the collision, Kendall requires assistance with her activities of daily living?
Again, I would not phrase things that way.
What is the problem with the phrasing of the question?
Perhaps the word quote admit close quote has some legal connotation that I do not understand, but in common parlance, it is not a word I would use.
Okay, well, let's start over with a different word. Do you agree that Kendall Thomas has a severe traumatic brain injury?
I would say that is my understanding based on the materials I reviewed, based on the testimony of others.
Do you agree that after the collision, Kendall requires assistance with her activities of daily living?
That is my understanding, yes.
Do you agree that after the collision, Kendall requires a feeding tube?
Again, that is my understanding from the materials I reviewed.
Do you agree that Kendall Thomas did not have a traumatic brain injury before she was hit by a car?
Again, yes, that is my understanding.
Do you agree that before the collision, Kendall did not require assistance with her activities of daily living?
Yes, again, that is my understanding.
Do you agree that before the collision, Kendall did not require a feeding tube?
Yes, again, that is my understanding.
Do you agree that the records show that the collision caused Kendall's traumatic brain injury?
I think that question is outside my area of expertise.
Okay. Do you agree that the life expectancy of an average healthy 15-year-old female is about 65 years?
Approximately 65 additional years, yes.
Okay. And am I correct that your opinion in this case is that Kendall's life expectancy is 18 additional years?
Yes.
But you'd agree that if Kendall was normal, healthy, and hadn't suffered a traumatic brain injury, her life expectancy would be approximately 65 additional years.
I was not retained on the issue of what her life expectancy would have been today had the accident not occurred, but I agree that an average 15-year-old female does have a life expectancy of roughly 65 additional years.
Okay. You agree that life expectancy is just an average time a person has to live?
I would not phrase things as such, but I agree that the life expectancy is the average survival time amongst a group of similar people.
Would you agree that a life expectancy is not a prediction of when someone will die?
It is not meant to be. No, not in strict scientific terms.
Okay. And you can't predict the actual date on which Kendall Thomas will die, can you?
Not with 100% certainty, no.
You admit that it's possible that Kendall might live another 40 years.
I would not phrase things that way, but I agree it's possible, though unlikely, that she could survive for 40 additional years.
Okay. Would you agree that it's possible that Kendall might live another 50 or 60 years?
Again, it's possible, though it's extremely unlikely, certainly less than a 5% chance.
Sure. But you can't rule that out with absolute certainty, can you?
Well, I just said that there's a less than 5% chance. I did not say there was a 0% chance.
Less than 5% is not absolute certainty, is it?
Well, 5% means 1 out of 20 people like her would live 50 additional years.
And so you can't rule out that she might live another 50 or 60 years with absolute certainty, correct?
I can, with a reasonable degree of scientific certainty, say the chance that she or someone like her would live 50 more years is roughly 5%. But as I said, it is not 0.
Sure. So that wasn't my question to a reasonable degree of scientific certainty. My question was, it's possible that Kendall, or you can't rule out that that Kendall might live an additional 50 or 60 years with absolute certainty, can you?
I'm afraid that the wording of the question does not make sense in scientific terms in general, and it does not make sense in terms of life expectancy calculations. So I've tried to clarify twice in the interest of being helpful.
So isn't it true, sir, that Kendall's parents only get to ask the jury to make them whole a single time?
I'm not an expert on the law. That question sounds like it's outside my retention here.
Sure. You'd agree that Kendall's parents don't get to come back and ask the jury for more money if she lives to be 80 years old, though, right?
Again, that question is outside the scope of my retention here and outside my area of expertise.
Do you know the answer?
I have an understanding, but I'm not here to give my personal opinions or my understandings that are outside my area of expertise.
Sure. What is your understanding?
Well, in general, I understand that there's a lawsuit here. It involves a motor vehicle accident. It involves Kendall Thomas, who is now unfortunately severely disabled. My understanding from the materials is that she requires assistance with all activities of daily living, and that she will likely need such assistance for the rest of her life. I understand that a claim is being made for damages in general, and that would include the cost of future care.
What's your understanding about whether Kendall's parents will get to come back and ask the jury for more money if Kendall survives to be 80 years old?
I've not heard of that. My understanding is that a decision is made now about her future care costs.
So would it be fair to say then that your understanding is that Kendall only gets one chance to ask the jury for money?
No, I did not say that.
So that's not fair to say.
I don't know. I don't know the law. I don't know the appeal process. I don't know contingencies.
Okay. And sir, to be clear, you're not a medical doctor, correct?
Correct, I am not.
Okay. Can you see plaintiff's exhibit A on your screen?
Yes,
And have you seen your deposition notice for this case before?
yes,
No, I'm gonna scroll to the 5th and 6th pages. Have you seen this list of materials that you were requested to make available?
yes.
And I know we're not in person, so you can't physically hand me a binder or anything, but do you have access to these materials today?
Yes, and I provided my entire file to counsel in advance.
Okay. Did you bring the underlying data for Kendall's life table?
That there is no such thing.
There's no underlying data for Kendall's life table?
No. Or the question doesn't make sense.
Okay. Are there any materials that you have related to this file but didn't make available?
I think I sent my entire file, including the billing information, but if I haven't, then I'm happy to do so now.
Sure. Okay. Are there any materials that you were instructed not to bring?
No.
Okay. So I'm gonna, this time I'll mark Dr. Chevelle's entire file is plaintiff's exhibit 680, which I'll provide after. That's written.
Didn't we have a 680 in Cantors?
I don't think we made it to 680. We made it to 679.
Okay, okay.
Just a moment here. Can you see plaintiff's exhibit 681?
Yes.
And is this your fee schedule for this case?
Pardon my pause here. We raised our rates to $650 an hour this year.
Okay. Do you have any understanding as to whether this was the fee schedule that you agreed to with the defense in this case?
Yes, we agreed to the lower rate because I was contacted last year, $600 an hour. So that fee schedule is correct.
Okay. And so all cases originating on January 1st, 2023 onward would be $650 an hour?
Where I was contacted January 1st or onward, yes. This case, I was contacted last year, I believe, and materials were sent early this year.
Okay. And then did your fee for long distance travel and overnight trips also go up?
Yes, it would be $650 an hour or $6,500 a day, whichever is less.
Okay. So for cases originated under this schedule, you would charge $600 an hour for basically all of your work on the case. Is that correct?
Yes,
And then you estimate record review at 1 to 10 hours under this agreement?
yes,
And then you estimate 5 to 8 hours for analysis
yes,
and 3 to 8 hours for creating the report.
yes,
And then you estimate 4 to 6 hours for deposition preparation, excuse me.
yes.
And how much time did you spend preparing for today's deposition?
Roughly 3.5 hours.
Okay. And then you estimate trial preparation at 5 to 15 hours.
Yes,
So using the most conservative estimates on any case in which you're deposed, you're billing about 13 hours plus deposition time. Is that correct?
yes,
And you have a 2-hour minimum for depositions. Is that right?
yes,
So at least if you're in any case that you're deposed, you're billing at least 15 hours.
usually, yes.
Okay. What percentage of Strauss and Chevelle's income is from litigation consulting?
Probably about 95%.
What is the other 5%? Where does that income come from?
Other consulting outside of litigation, mostly on life expectancy.
What to the extent there is an average or typical client that would fall into that 5% bucket, what does that client look like?
It's a variety of things, including work in what's called the senior settlement market, doing life expectancies for workers' compensation carriers, doing consulting work for life annuity firms, and other one-time projects.
Okay. How many testifying experts are employed by Strauss and Chevelle?
3, Dr. Strauss, Dr. Brooks, and myself.
And how long have y'all had this arrangement?
The company was formed in 1999. Dr. Brooks joined in the mid 2000s, perhaps 2005.
Okay. So your testimony list provided in this case includes 568 instances in which you've offered testimony either at deposition or trial. And so my question is that a complete list of all deposition or trial testimony?
Up through the dates on the list, it should be, yes.
Have you, is there any testimony, whether it be deposition or trial, that you have given but does not appear on that list at the, in the recent months or so?
If I could be told what dates are the most recent deposition and trial on the list that's been produced, then I would know.
Okay. Of the 568 times that you've testified, would you agree that 95% of it has been on cases in which you were retained by a law firm representing a person or company who was alleged to have injured someone?
Object to the form, but you can answer.
I would not phrase things that way, but I would agree that perhaps roughly 95% are defense retentions and 5% are plaintiff.
Okay. Also on the 5% plaintiff retention, what types of cases are you retained by plaintiffs?
The same types of cases where I'm retained by defendants, which would be personal injury, medical malpractice, wrongful death, mostly.
And in those cases where you're retained by the plaintiff, is the plaintiff, to your understanding, someone who has been injured?
Well, as I said, it would be a personal injury or a wrongful death, or if it's the estate of the decedent.
I've got
I'm
some.
sorry, I should have said personal injury or medical malpractice or the estate of the decedent.
Okay. Now I've got some math questions for you. So you'd agree that 568 times 9,000 is just over 5.11 million?
If the 9,000 is dollars, yes.
Yeah. And then you'd agree that 95% of $5.11 million is $4.85 million?
Yes, the arithmetic appears correct.
Okay. Would you agree that defense testifying has made you a lot of money over the years?
I would say that all of my earned income is from Strauss and Chevelle Inc. And that 95% of the litigation consulting is retention by the defense.
Okay. Can you see plaintiff's exhibit 685?
Yes.
And the first paragraph says, my name is Robert Michael Chevelle. The second paragraph says, I've been paid over $4.5 million for calculating life expectancies of individuals in cases in which I was hired by a law firm representing a person or company who injured someone. Do you agree that that's what that says?
Yes.
Is that accurate?
No.
What is inaccurate about it?
Two main things. Firstly, I'm not hired, I'm retained. Secondly, the money does not go to me, it goes to the company, Strauss and Chevelle Inc.
Okay. So if we change the I to Strauss and Chevelle Inc. and then hired to retained, would it be accurate then?
No.
What else would be inaccurate about it?
Well, let me just state what I believe the truth to be. Strauss and Chevelle has been paid monies over the years from both plaintiffs and defense to consult on life expectancy in a litigation and in other settings.
Okay. Would you agree that Strauss and Chevelle has been paid over $5 million for consulting on litigation related matters involving life expectancy?
I don't know if that's correct.
Do you know if Strauss and Chevelle has been paid over $4.5 million for calculating life expectancies on litigation cases?
I don't know, and I'm not sure it would be appropriate for me to agree or disagree to any question involving a gross dollar amount.
How is that inappropriate?
I said I'm not sure it would be appropriate.
Okay, so are you refusing to answer?
No, but I will say it is not our practice to talk about gross dollar amounts, except the number of hours and dollars on a given case, such as this one. I've already conveyed percentages, and I could convey how I spend my professional time if that's of interest. It's also not our practice, as indicated on the fee schedule, it is not our practice to reveal such information. I also don't see how it's relevant to a scientific determination of life expectancy.
Okay, well, I want to take a 5-minute break. And then we could pick up at, let's say, 2:30. All right, Dr. Chevelle, I just hit the drawing board and made some changes. So let's take a look. This. Can you see this Word document?
Well,
Yes.
before we go any further, I'm gonna put my objection on the record. We have no idea where this document's from, what this is about. There's no foundation for this or basis for this. These are not statements that have been made by Dr. Chevelle, and we're just gonna object.
Okay. Dr. Chevelle, can you see this Word document?
Yes, I can.
All right, so under heading number 1, my name is Robert Michael Chevelle. That's true, isn't it?
Yes.
Number 2, I have testified in deposition or trial on 568 instances involving life expectancy calculations. On 95% of those cases, I was retained by the defense. That's true, isn't it?
I haven't counted, so I don't know if it's 568, and I would say perhaps roughly 95% I was retained by the defense.
No. Roughly 95. So, all right. So number 2 now reads, I have testified either in deposition or trial on about 568 instances involving life expectancy calculations. On roughly 95% of those cases, I was retained by the defense. Is that true?
It's my best estimate as I sit here. Yes.
Okay. And then the third paragraph reads, Based on my work, Strauss and Chevelle has been paid over $4.5 million for calculating life expectancies of individuals in cases in which I was retained by a law firm representing a person or company who injured someone. Is that an accurate statement?
No.
What about that statement is inaccurate to you?
Firstly, I don't know the dollar amount, and secondly, the last part of it,
Which part?
where it says, quote, who injured someone, close quote, is outside my area. It seems to assume liability.
Okay, so paragraph 3 now reads, based on my work, Strauss and Chevelle, strike that. Number 3 now reads, based on my work, Strauss and Chevelle has been paid millions of dollars for calculating life expectancies of individuals in cases in which I was retained by a law firm representing a defendant in a personal injury case. Is that a true, inaccurate statement?
I don't know, because remember earlier I said that I'm involved in personal injury, medical malpractice, and wrongful death matters.
Okay, so paragraph 3 now reads, based on my work, Strauss and Chevelle has been paid millions of dollars for calculating life expectancies of individuals in cases in which I was retained by a law firm representing a defendant in a personal injury, medical malpractice, or wrongful death case. Is that a true and accurate statement?
I'm not sure it would be appropriate for me to agree or disagree about a question involving a gross dollar amount for the reasons I said earlier. And I would add to my earlier answer that I have signed an employment agreement and also a confidentiality agreement, as have all the employees of the company. So I am contractually bound not to answer questions, provide information about the revenue to the company. I do not want to be in breach of contract because I understand that can have serious consequences.
So you are going to refuse to admit, or excuse me, you are refusing to agree that your work has generated millions of dollars for Strauss and Chevelle over your career.
Objection, that's misstating his testimony, and he has actually provided you with a full and complete answer to that question multiple times now.
No, I would not phrase things that way.
How would you phrase it?
Well, for the many reasons I have given, I am not at liberty to answer questions about a gross dollar amount for the entire company.
Oh, I'm
Therefore,
asking.
in an abundance of caution, I cannot answer today.
So this question is not based on the entire company. It's based on your work as a principal of the company.
The same would apply.
Okay. Do you have the document on which you're relying for your refusal to provide the information I'm asking?
Objection.
I'm afraid I can't agree with the question the way it's phrased, so I'm not sure how to answer.
Do you have the document that says you can't tell me about gross revenue?
Well, one such document has already been marked as Exhibit 681, our fee schedule.
Where on your fee schedule does it say that you can't tell me any information about gross revenue?
Note number 2.
Number 2. Okay, well, is there any document other than note number 2 that says that you are not legally allowed to tell me how much money you've been paid for your testimony.
Objection, mischaracterizes his testimony. He's already asked and answered.
Is note number 2 the sole document that you're relying on for not telling me how much money Strauss and Chevelle has been paid based on your testimony?
I'm going to object to the form. I'm going to object to the mischaracterization of his testimony, and I'm going to object as that he has already answered that question multiple times.
Okay, he hasn't answered that a single time, and it's not mischaracterizing any testimony, it's asking him a question. So do you remember what the question was?
There were several questions, and I'm afraid that the phrasing of them was incorrect.
How so?
Well, firstly, I would not agree that I was paid for my testimony or that the company was paid for my testimony. What is true is that I was retained and that the company was compensated for my professional time.
All right. Paragraph 3 now reads, Strauss and Chevelle has received millions of dollars based on my professional time involving the calculation of life expectancies of individuals in cases in which I was retained by a law firm representing a defendant in a personal injury, medical malpractice, or wrongful death case. Is that an accurate statement?
Well, again, for the reasons I gave earlier, I cannot provide information about gross dollar amounts. But if in this item number 3, it merely says payment rather than as stated, then of course it's true.
All right, so I think we have an agreement now. So paragraph 3 now reads, Strauss and Chevelle has been paid millions of dollars based on my professional time involving the calculation of life expectancies of individuals in cases in which I was retained by a law firm representing a defendant in a personal injury, medical malpractice, or wrongful death case. Is that accurate?
No, as I said, I cannot provide information on a gross dollar amount. So any gross dollar amount would have to be removed from this document.
Okay. So you will not agree to the accuracy of this document?
I'm not at liberty to do so, and therefore, in an abundance of caution, I cannot do so today. I'm a 45% shareholder of Strauss and Chevelle Inc., therefore I cannot make decisions unilaterally.
Okay. Has any court ever ruled verbally or by written order that you were not qualified to testify as an expert about any subject?
I'm not sure about that exact language, though to give a complete answer, I would say that I have been precluded on 5 very unusual occasions.
Okay, let's go through each of those occasions. What is the first occasion on which you were precluded from testifying?
A matter called Scott versus Baylor University Medical Center. I believe my deposition was in 2005 in Texas. Pardon me, the case was venued in Texas. My deposition was taken here in San Francisco.
Okay. On what basis was your testimony precluded?
The court order did not state a reason, though I do have an understanding
What is your understanding?
that the court did not have all the relevant information before it when it made its ruling. because the defense did not show me either of the two motions to preclude or their response or allow me to assist. I found out about the preclusion years later.
Was it just an outright preclusion, or was it limitation on the subject matter on which you were able to testify?
I think it was outright.
And you were not provided with any rationale or explanation as to why you were precluded?
The court order did not give a reason.
Did the attorneys explain to you why?
Not that I recall.
Okay. All right, what's the second instance in which you were precluded from testifying?
It was in 2007. It is not on my case list because I did not give deposition or trial testimony. It was a matter called Smolinski, SMOLINSKI versus Ford Motor Credit Company, I believe. A case venued in Buffalo, New York. I was told by defense counsel that all of the defense experts were precluded and that it had nothing to do with their qualifications or opinions.
Did you ever see an order explaining the basis of the preclusion?
No,
Is it your understanding that the experts were precluded from testifying as a sanction?
I do not know.
And then in the Smolinski case, were you retained by Ford Motor Company or Ford Motor Credit Company?
Yes. Or by an attorney representing them.
Okay, fair. What was the subject matter of that case?
I believe it was a motor vehicle accident, and I was retained to testify on the life expectancy of the injured gentleman who had suffered a spinal cord injury.
Okay, and I actually skipped over that question on the first one. So in Scott v. Baylor University Medical Center, who retained you?
An attorney who represented Baylor, I believe.
Okay. What's the third instance on which your testimony was precluded?
It was in 2007, a case called Giddens, GIDDENS versus Cleveland Regional Medical Center. It was venued in Liberty, Texas. It should be on my list.
Okay. What was the reason your testimony was precluded in that case?
The court ruled that my office address would not suffice as an address for the purposes of my deposition that day. The court ruled that I had to provide my home address, I had to put it on the public record, and that I had to do so immediately. The defense asked me not to recuse myself and asked for permission not to withdraw me so that I would be excluded. They told me they were collecting reasons to appeal the case.
Okay. Do you give deposition testimony from your personal home?
No,
Where are you right now?
in my office in San Francisco.
Okay. And so the defense withdrew you as the expert in the Giddens case?
No,
So there was an actual court order precluding you from testifying?
no. As I said, the judge ruled during my deposition. The deposition was held at the courthouse. The judge was asked to come into the room and to make a ruling.
Okay. And you, in Giddens, were you retained by a lawyer representing Cleveland Regional Medical Center?
Or one of the other defendants, yes.
And is it safe for me to assume that that was a medical malpractice case?
It was, yes.
Was there a death involved, or was it an injury case?
I believe it was a medical malpractice case involving a girl with sickle cell anemia.
Okay. What was the fourth instance in which you were precluded from testifying?
This one is not on my list because I did not give deposition or trial testimony. It was called Snyder, SNYDER versus Mitchell and others, venued in Allegheny County, Pennsylvania.
And what was the reason your testimony was precluded in the Snyder case?
Well, the plaintiffs filed a motion the day before, or 2 days before I was to appear at trial. The defense thought it was untimely and wouldn't be heard and didn't tell me about it and did not respond. When I landed in Pittsburgh to appear at the trial the next day, they called to tell me that I had been precluded. So obviously I did not see the motion in advance, did not assist them in any response. And as I said, they did not respond.
Okay, so was the basis of the preclusion simply that a timeliness issue, or did it reach the merits of your testimony?
Well, perhaps I misspoke. I said that the defense thought that the motion was untimely and that it would not be heard by the court. They were obviously mistaken.
What was the basis of the exclusion?
I don't recall the details, though. I believe that the court said that I was not able to testify on life expectancy based on the medical literature, even though I had written some of it.
What was the issue as far as you understand with the medical literature?
Well, I didn't think there was any scientific issue with the medical literature. I thought it was recent, relevant, reliable, helpful. I was not aware of any significant limitations in the articles we had written or others had written.
What issue did the court focus on with respect to the medical literature?
I do not recall.
Do you remember whether it had to do something, sorry, it's late in the afternoon. Do you remember whether it had to do with the reliability of the articles?
I do not recall that, no.
Do you remember whether it had anything to do with the methodology of the articles?
No, I do not recall that either.
Okay. What was the subject matter of Snyder versus Mitchell et al.?
I was asked to give an opinion on the life expectancy of a young girl who suffered a near drowning accident in the backyard pool of Mr. Mitchell.
And were you retained by the defense in that case?
Yes.
All right, what was the fifth instance in which your testimony was precluded?
It's on my case list. My deposition was September 19, 2022, a matter called Ruvalcaba, RUVALCABA versus City of Victorville.
Okay, what was the basis of your preclusion in that case?
I'm not sure that there was a court order or that the court gave a reason, but I do know plaintiffs filed a motion and the defense did not file a response, and the defense did not show me the motion or talk to me before the ruling was made.
And it's safe to assume that you were retained by the defense in that case?
Yes.
And what was the subject matter of that case?
It was a wrongful death case. Mr. Rubalcaba, to my understanding, had assaulted a city of Victorville worker, and another worker rushed to the defense and hit Mr. Rubalcaba in the head with a shovel.
And I'm sorry, what was the year of this case?
My deposition was last year,
When did you learn that you had been excluded in that case?
last year.
When you're excluded in cases, which obviously doesn't happen often, when you are, do the lawyers who retain you typically provide you a copy of the order?
Yes,
And is that something that you keep in the ordinary course of your business with Strauss and Chevelle?
yes,
Do you have access to those orders as we sit here today?
if they exist, I would or should.
Okay. Well, we would ask that those orders be produced. We can deal with that later. Other than these 5 instances in which you were precluded from testifying as an expert, are there any other cases in which you were precluded or limited in any way?
I don't believe so.
What is life expectancy?
As a discipline, it would refer to the study of survival, the factors that affect survival and by how much. As a narrow technical term, it means the average survival time amongst a group of similar people.
And what are the various factors that you generally consider when calculating a life expectancy?
Well, that's a general question. I'll give a general answer. Demographics such as age, sex, race, country. Lifestyle factors such as smoking, drinking, drug abuse, height and weight, exercise, physical fitness. Medical factors like heart disease, cancer, stroke. Disabilities, such as those that could happen after an accident or due to a stroke. There are other factors that may come into play, occupation, rarely.
Okay. As far as age goes, is it true that mortality risk generally declines as a individual gets older?
No, it increases.
Mortality risk increases.
Yes, and life expectancy decreases.
Okay. Is it true that mortality of males is generally higher than the mortality of females?
In most cases, yes, though amongst the severely disabled, there isn't much difference.
So in other words, in a general sense, females generally live longer than males. Is that correct?
Yes.
All right, you had mentioned disabilities. How does a disability impact a life expectancy generally?
Generally, the more severely disabled a person is, the lower their life expectancy compared with someone who's less severely disabled. And that would be true in traumatic brain injury, anoxic brain injury, spinal cord injury, cerebral palsy, and stroke.
Okay. On a scale of 1 to 10, how severe are Kendall's injuries from the collision?
I wouldn't use a numerical scale like that, nor does the literature.
Okay. How would you describe the severity of Kendall's injuries?
Well, in general, we already discussed this, that my understanding is that she's severely disabled, and typically that term is used to refer to someone who cannot walk on their own. But it could be used to refer to a severe cognitive impairment or a severe limitation in self-care as well.
And then another thing you mentioned I guess you didn't use this word, but comorbidities would be another factor to consider, or pre-existing conditions. So,
Well, there are two issues there. Someone who's injured might have complications or sequelae, or as you said, comorbidities as a result of the injury or the medical condition. There are also instances where someone had pre-existing risk factors or conditions prior to an injury or an event.
as far as you know, did Kendall have any pre-existing risk factors?
No,
She did not.
correct. She did not. To my understanding, she was healthy, or at least relatively healthy, prior to the motor vehicle accident.
Okay. So, and I know that this is probably seems obvious, but you agree that Kendall did not have a pre-existing traumatic brain injury, correct?
Well, that's my understanding, as I said at the outset.
Mhm. And would you'd agree that before the collision, Kendall was a normal, relatively healthy girl?
That is my understanding, but as I said at the outset, I was not retained to opine on what her life expectancy would have been today, but for the accident.
Okay. Is the education level of the patient's primary caretaker relevant to life expectancy?
I'm not aware of any scientific or medical evidence to show that it's a significant factor given everything else. No,
Is that a factor that has just not been, is that a factor that just hasn't been studied as far as you know?
I don't know that that narrow topic has been investigated solely on its own merits, though it may have been investigated indirectly or implicitly in a larger context.
Is it, would it be safe to assume that generally the higher the level of education of the caretaker, the better the care provided? That is a terrible question. Is there a correlation between education level and the quality of care provided when you're talking about, an at-home caretaker?
I'm not aware of any evidence that shows a difference. No.
Okay. Is the quality of care that a patient receives a relevant factor in determining life expectancy?
It could be, depending on what we are comparing.
Is the assumption, or do you generally make an assumption that the person whose life expectancy you're calculating is receiving quality care?
My understanding and the implicit assumption, I suppose, in the calculations is that the person will receive reasonable and necessary medical care going forward.
Excuse me. Is Plaintiff's Exhibit 682 on your screen?
Yes,
And this is the life table for Kendall Thomas that you prepared in this case, correct?
yes.
Can you just sort of explain to me how you prepared it?
Certainly. Briefly, this is a life table I constructed to summarize my opinions. So I first reviewed the materials about her, secondly, analyzed the medical literature, thirdly, arrived at an opinion of 18 years, and then finally constructed this life table to demonstrate or show that 18 years.
Okay. And then can you just walk me through the meanings of the letters in the top column, top row, I guess?
Sure. The first column is age. Age is denoted by lowercase x in the subsequent columns. So the second column is lowercase l and then in parentheses lowercase x. In scientific terms, it would be pronounced L of X or L at age X. This column is called the survivorship function by convention in demography, which is the field in which life tables were developed. It begins with 100,000 people alive at the initial age, and then it follows that group forward in time or age. So that, for example, by age 30, 48,981 of the initial group are still alive, or roughly 49%.
Okay, and then the next one.
Lowercase d is the average number of deaths in each 1 year age interval. Lowercase q is the annual mortality probability or the chance of death. Lowercase m is the annual mortality rate. The rate is always slightly larger than, though quite similar to, the probability. Uppercase L and uppercase T date from the time when life tables were constructed by hand calculations. So these are placeholders for the arithmetic. Uppercase L is the number of person years lived during the 1 year interval, and uppercase T is the sum of the uppercase L column from each age forward. So it represents the cumulative number of person years lived from that age onward. And then the rightmost column, lowercase e, is the remaining life expectancy at each age. And it's calculated as uppercase T divided by lowercase l. So it's the total number of years divided by the number of people. And thus it's seen to be a true arithmetic mean.
Okay. So why is it that you start with 100,000 in the lowercase l column?
As I said, it is a convention in demography. It could equally begin with 100%.
Okay. And so L means if we go to 15 and then there's 100,000, L means that you're beginning with 100,000 people who are 15 years old.
Yes.
And then so like if we skip down to 40 in that category, that means that, you know, Kendall survives to be 40 years old, then there would be, I guess, let me back up. So 100,000 in at 15 under L means 100,000 people similar to Kendall.
Yes.
And what is the, like, what criteria are you including in people similar to Kendall?
The key facts listed on the document titled Life Expectancy Analyses regarding Kendall Thomas.
Okay. And then, like, what are you relying on? What medical literature are you relying on to extrapolate, you know, these numbers? Like, how do you know that they're similar to Kendall?
Well, firstly, I wouldn't use the term extrapolate. Secondly, in answer to the question, the principal medical literature I relied on is listed on the document titled Life Expectancy Analyses regarding Kendall Thomas. Those will be principally references 15, 7, and 22 on the bibliography.
Okay. And those studies, they didn't look at 15-year-old girls with TBIs, did they?
They did look at 15-year-old girls who had suffered a traumatic brain injury.
Okay. So going back, so we go down to 40, meaning Kendall is 40 years old. And then the L column means that there are still, of the initial 100,000 people, similar to Kendall, there are still 28,758 that are alive.
Roughly, yes.
Okay. And then if we go to 60 years old, meaning Kendall is 60 years old, lives that long, this column, the L column, would mean that there are 5,976 people similar to Kendall that are still alive.
I'm sorry, I should have clarified the prior question. Kendall is 15 now. She's not 40 or 60 or 80. Amongst a group of persons like her now, roughly 6% would survive to age 60.
Okay. And then the last column is just the number of years left, the life expectancy. So like if Kendall were to live to be 60, she would have a life expectancy of 7.2 years. Is that correct?
If she were amongst the roughly 6% like her now who survived to age 60, and if her condition at that age were typical of such people, then yes, the life expectancy from that point forward would be approximately 7 additional years.
Okay. In reaching your life expectancy calculation for Kendall, have you considered the remarkable progress that she has made so far?
Well, let me just say I have accounted for the progress she has made thus far. My opinions are based on her current condition. As to whether that progress is remarkable or better or worse than expected, it matters not for my purposes. And that question may be better posed to someone else.
Okay. Have you considered that Kendall's parents' care for Kendall has been exceptional?
It's outside my area of expertise and the scope of my retention here to opine on the quality of care she has received from anyone, including her parents.
So
So
that hasn't been factored in.
Though I have no reason to doubt that she has received good care from her parents. I saw no indication to the contrary.
Have you considered that Kendall is in a loving and caring home?
That is my understanding. But it's not a factor that I explicitly used to adjust the life expectancy, because I'm not aware of any scientific or medical literature or evidence that shows that that factor is a significant one for survival once we account for everything else.
Okay. Have you considered that Kendall has a strong will?
It's outside my area of expertise and the scope of my retention here to opine whether that is true. And again, if it's true, I'm not aware of any evidence to suggest that it's a significant factor for survival amongst people with similar disabilities.
So I think the tail end of that was the answer to the question. So Kendall, assuming Kendall has a strong will, it's your testimony that that's not a significant factor for survival amongst people with similar disabilities.
I'm not aware of any evidence to show that it is. If there were such evidence, I'd be happy to consider it and to revise my opinions if appropriate.
Okay. Have you considered that Kendall has already overcome huge hurdles in her recovery?
Implicitly, yes, though it's outside my area of expertise and the scope of my retention to opine whether the hurdles were large.
Yeah. Can you see plaintiff's exhibit 683?
Yes,
And are all of your opinions outlined in this summary sheet?
it's a complete summary. Yes.
Are there any other opinions that you have that we have not talked about?
If we include all of my file materials, that encompasses all of the opinions and bases for those opinions that I've formed to date. And as I said, Exhibit 683 is a complete summary, to my knowledge.
Okay. And I believe you already testified this, but you reside in San Francisco, California?
I did not testify to that. I said that I am in my office in San Francisco now.
Okay, where do you live? And you don't need to tell me your personal address. I just need to know the city and state that you live in.
California.
You are not going to provide the city that you live in?
I can't see how it's relevant to a scientific determination of life expectancy.
So it's relevant to how this deposition can and will be used in the future in this case. So it is relevant, respectfully. What city do you live in?
I'm not sure it would be appropriate for me to put that on what is a public record for reasons I could explain.
Please do explain.
Well, firstly, as I said, I can't see how it's relevant to a scientific determination of life expectancy, which is what was my retention here. Secondly, I've provided my office address on all the materials, including my CV. I can be reached at the office or through counsel. I will agree to receive a subpoena at the office or through counsel or in the mail. If that's helpful. Thirdly, it's not our practice to reveal personal information. That's indicated on the fee schedule, in fact, which has been marked as Exhibit 681. And then fourthly, as I said earlier regarding the company income, I've signed a confidentiality agreement and an employment agreement with the company. That agreement limits the information I can provide about myself or others, including home address. I do not want to be in breach of contract because I understand that can have significant consequences. And so therefore, I'm not at liberty to provide my home address at this time.
Okay, and just for the record, I did not ask for your home address. I asked for
Matt, if we can just go off the record for one quick second, Matt.
okay.
Are we good? Okay, so there have been situations in the past where members of Dr. Chevelle's office and team have been personally harassed by counsel and parties in other cases. Obviously, no one is suggesting that you would do that or that would happen, but there is a good faith reason why all of this came about in the first place. So
Okay. Understood.
it's not that he's trying to be difficult, but there's a very real and legitimate reason why that all happened in the first place.
Understood. Okay. And as long as y'all will stipulate to his unavailability such that we could use his deposition however we want, then, you know, that's fine.
Okay, yeah. Well, yeah, we're good.
Okay. All right. Just give me 5 minutes.
Okay.
And then could be almost done.
All right.
Thanks.
Yeah.
All right, ready when you guys are.
We're good, yeah.
Okay, excellent. So we're almost done. I want to go back to, can you see the document that we had been working on earlier?
Yes,
So I think we are in agreement on points 1 and 2. And on point 3, we're pretty much in agreement about everything except the fact that you don't feel comfortable or feel that you're contractually bound to not disclose gross revenue. Is that a fair characterization of paragraph 3?
roughly, yes.
Okay. Now, in terms of the revenue, obviously, we can send a subpoena to you, to your company and figure that out. Rather than incurring all of the expense of doing that in time, my preference would be to hammer it out here. So will you agree at least that millions of dollars have been paid to your company without giving a specific number, of millions?
I'm gonna object for all the reasons previously stated for this line of questioning.
Noted.
I would merely repeat the lengthy answer I gave previously.
Okay. Okay, give me just one moment. We can go off the record. I'll be right back. Just gonna do something here. All right, ready to get back on when everyone else is.
1 second. I don't want to make it too much noise. I'm spilling out my water.
Hmm,
I'm good.
okay, all right, Dr. Chevelle, is plaintiff's exhibit 685 back on your screen?
Yes,
All right. So give me a second. I'm going to be using the annotation feature on Zoom, and I'm not very good at that, so bear with me here.
Well, and just while you're doing that, I'm gonna object to the use of this document, the origin of the document, the information contained in the document for all the reasons previously stated.
Okay. So Dr. Chevelle, we have agreed that point number 1 is true and accurate, correct?
Yes,
So I'm gonna, for the record, I'm gonna place a green check mark next to it to indicate that you agree with it. Point number 2, I believe we've agreed is true and accurate, which says I have testified either in deposition or trial on about 568 instances involving life expectancy calculations. On roughly 95% of those cases, I was retained by the defense. Is that true and accurate?
I don't know. As I said, I haven't counted on my list, but I know it's 20 some pages and they're probably at 25 items per page.
Sure. So
Oh, it would be at least 500.
okay, well, let's change it then so we can get it right. You'd agree to the at least 500?
Yes.
Actually, you know what? Hold on. Let me call it stop share. Materials. All right. Can you see this Word document?
Yes.
All right. So these are the dates of every deposition that you listed on your testimony list, just with whatever any line removed except for the date. I started doing just the dates and then realized that was going to take me a very long time, and just did it by line so I could count the line. You see there it says 568 lines.
Yes.
Do you agree that there are 568 cases on this list? I'm happy to pause and let you count them, but
I'm gonna object. I mean, even on my screen, it's small text. There's no way to know. That's not the actual document that was prepared, that was provided to you. And it's not even consistently set up. I mean.
okay, well, we can pause it and then come back after he's had the opportunity to count the list if you'd rather do that. Do you want to take a break to count the list?
Let me just say, in the interest of being helpful, that some of the depositions and trials represent the same case. And that's why I said more than 500.
Let's take a break and give you some time to count the list, and then we could come back. How long do you want? 10 minutes to count the list?
What is it specifically that you want him to do? Because he just testified that the list has multiple references to the same case in some instances. So do you want a number of lines? Do you want the number of cases? What are you looking for?
Number of times that he's testified.
Whether it's been multiple times in the same case or not?
Actually, that's a good point. Let's just go with cases, the number of cases. Should we come back at 3:40? All right, Dr. Chevelle, how many cases have you testified on or involving life expectancy calculations?
The case list has about 530 depositions and about 90 trials. Most of those, more than 95%, involved life expectancy. There's some overlap between the depositions and the trials. So the total would be less than 620, say roughly 600 times. And of those, roughly 95% were defense retentions. So that would be roughly 570 defense and 30 plaintiff.
Okay, all right, so let's, so right here, so you said 600 instances?
Well, the testifying would be 620, but it would probably represent about 600 distinct cases.
Instances. Okay. How does that look?
Correct.
All right, so number 2 is correct now. Number 3. If we agree to mark this portion as confidential, will you agree to number 3?
No.
Let the record reflect that defense counsel just shook her head no. All right. All right.
Let the record reflect, I shook my head no, not because I was instructing the witness, but because I cannot believe you continue to ask the same question that he has told you over and over again he cannot answer.
Noted. All right, give me just a second to clean this up in the final PDF format, and then we will be done. Just a moment here. Is the screen, are we back on the record? Is the screen shared 685?
I can see it.
Okay, so I will submit plaintiff 685 as it exists. There have been a lot of changes made as it currently exists as plaintiff's exhibit 685 to the deposition. And I have no further questions.
We're gonna object to the exhibit for all the reasons previously stated. I don't have any questions.
May I state on the record, please, that I would like to read and sign?
Yes, we were gonna ask you that. Okay.